Good day. We would like to wish our beloved lecturer, Puan Siti Zubaida, and fellow friends. My name is Kanimolli Dinahgaran. I am from Group 4. Today, my group mates and I are going to present about Chapter 7, which is Winding Up. Before that, I would like to introduce my group mates. My group mates consisting 4 people, which are me, myself, Kanimolli Dinahgaran, Sakti, daughter of Sathiyaseelan, Poojassri, daughter of Shanmugam, and finally Sneha, daughter of Manivannan. Now I shall proceed with the questions. So there are 2 questions to be presented in this winding up chapter. So let's go for the first question, which is differentiate between the compulsory winding up and the voluntary winding up. Now we will see the differences between compulsory winding up and voluntary winding up. For a compulsory winding up, according to section 464 subsection 1a, a compulsory winding up is commenced when a petition is presented to the court, whereas for a voluntary winding up is commenced according to section 432 subsection 2a in Companies Act 2016. It is commenced by a member's voluntary winding up where the company is solvent. Solvent means the company is in a stage where it is able to pay up its debts, and the liquidator is appointed by the members of the company in a members meeting. This is known as a members voluntary winding up, and according to section 432 subsection 2b, voluntary winding up is also can be commenced by a creditor's voluntary winding up where the company is insolvent. Insolvent means a stage where company is unable to pay its debts, and the liquidator is appointed by the creditors of the company at the creditors meeting. So it is known as a creditor's voluntary winding up. Now we shall see the reasons why a compulsory winding up shall be commenced to a particular company. So there are various reasons for a company to be wound up by the court, which is a compulsory winding up. So the reasons are provided in section 465 of Company Act 2016. So according to section 465 subsection 1a, the company has passed a special resolution that the company should be wound up by the court. Okay, the members of the company and the directors of the company had a meeting and has passed a special resolution that the company should be wound up by the court. Okay, the second reason according to section 465 subsection 1b, the company defaults in lodging the statutory declaration under section 190 subsection 3. The next reason is according to section 465 subsection 1c, the company does not commence business within a year from its incorporation or suspends its business for a whole year. Okay, for this case, I shall give you one instance. For example, DAT3B, a company called DAT3B has incorporated from January 1st, 2019. It has been incorporated on January 2019, 1st January 2019, but there's no business activities throughout the year from January 1st 2019 until December 31st 2019. So when there is no business activities occurring in that DAT3B company, so it has all kind of it has the eligible to be wound up by the court, which is compulsory winding up. So the next reason is, according to section 465 subsection 1e, a company shall be wound up by the court of a compulsory winding up is because the company is unable to pay up its own debt. Okay, for example, DAT3B company is in debt and it is unable to pay up the debts to the creditors. So it has all the eligibility to be wound up by the court or commence a compulsory winding up. A company can be commenced a compulsory winding up if the director act on his or her own interest. This is provided under section 465 subsection 1F. Now we shall see the reasons for voluntary winding up. According to section 439 subsection 1A in Companies Act 2016, the expiry of the period fixed by the Constitution or the occurrence of event provides that by the Constitution that the company should be dissolved. This is the first reason for a voluntary winding up. And the second reason is, according to section 439 subsection 1B, the company has passed a special resolution in a general meeting for the company to be wound up. Okay, for this, like I said just now, for the compulsory winding up, the same situation happens here. The members and the directors has held a meeting about the company to be wound up voluntarily.
Thank you, Kani. Good day to Puan Zubaida. My name is Poojassri Shanmugam. I will be continuing our presentation under sections under compulsory winding up and voluntary winding up. There's three more sections in compulsory winding up, which are section 465 subsection 1G, the company expires, section 465 subsection 1H, the company decision for the company to be wound up, and section 465 subsection I, the company license under Financial Act 2013 or Islamic Financial Service Act 2013 being revoked. Under voluntary winding up, there's one section which is section 432 subsection 2, members voluntary winding up and creditors voluntary winding up. Now we will proceed on to the second question given. The shareholders and directors of Das Surya's Indian Berhad, a company trading in beauty products, have decided to cease the company's operation at most are well past retirement age and have no plan to continue working. Furthermore, due to the economic slowdown, the business has not been doing well. Based on this situation, propose a directors of Das Surya's Indian Berhad on the procedure required to dissolve the company. Well, according to the situation given, Das Surya's Indian Berhad is proposing a voluntary winding up, more specifically, members voluntary winding up. My next teammate will be proceeding my next teammate will be presenting about this.
Thank you, Pooja. And I shall now move to our presentation, which is continuation of question 2A, which is in slide 7. This is because according to section 439 subsection 1 and 2 of Companies Act 2016, a company is allowed to be wound up voluntarily if the following circumstances occurs. A. The period fixed by the Constitution for the duration of the company expires, or 2. B. On the occurrence of an event that constitutions allow the company to be wound up and the company has passed a resolution in a general meeting to wind up the company voluntarily. C. The company has passed a special resolution to wind up voluntarily. Well, based on the slide 8, continuation of question 2A, thus as referring to section 439 subsection 1 and 2, the following procedures should be followed for the purpose of voluntarily winding up. First, the company should submit a copy of resolution to the registrar within 7 days from the passing of resolution, and second, give notice within 10 days after passing resolution, which is in one widely circulated newspaper in Malaysia in national language and is one widely circulated newspaper in Malaysia in English language. And I would like to share about something which is what is winding up, which is a creditor's winding up is less complicated than a compulsory winding up. It is also less expensive. Therefore, a creditor's winding up is preferred over compulsory winding up if the company has sufficient assets to pay the liquidation fee and expenses.
Good day. I would like to wish to Madam Siti Zubaida, our company law lecturer, and my fellow friends. My name is Sakti, daughter of Sathiyaseelan, and my registration number is 01DAT19F1054. I am from DAT3B. Now, I will be answering to the situation on how should we help the directors to dissolve a company when the company is insolvent. When the company is insolvent, or in other words we can say when the company is unable to pay the obligations when the obligations due, the category of winding up, or we can say the process of dissolving the company, is called creditors voluntary winding up. Do you all know that creditors voluntary winding up is winded up in a special resolution of the shareholders under the observation of the company's creditors? This is because the directors of the company are unable to provide a declaration of solvency, and therefore the company proceeds with the creditors voluntary winding up. Do you all know what is actually declaration of solvency? Declaration of solvency is a document which must be signed as a part of the formal solvent liquidation process in members' voluntary winding up. In this case, as the directors are unable to provide a declaration of solvency, this caused the company to proceed with creditors' voluntary winding up. Not only that, it is clearly stated under Section 432, subsection 2b, that there is no declaration of solvency needed in creditors' voluntary winding up. Now moving straight to the point, there are 5 steps to help the directors to dissolve the company which is insolvent. The steps can be found from Section 449 subsection 1 till Section 449 subsection 5. So there are total 5 steps which can help the director to find their ways to dissolve the company. Now I shall move on to step 1, which is from Section 449 subsection 1. In this section, it's clearly stated that the company should cause the creditors of the company to be presented on the day or the next day in which the meeting will be held for the purpose of resolution for the voluntary winding up to be proposed. The next step is from Section 449 subsection 2. In this section, the company shall cause the notices of the meetings of creditors to be posted to the creditors simultaneously with the sendings of the notices of the meetings, which was presented under subsection 1. The third step is from Section 449 subsection 3. In this section, it is clearly stated that the meeting should be convened at the time and place which shows the majority in the value of creditors, or in other words we can tell which is more favorable to creditors. Not only that, the notice must be also given to the creditors at least 7 days before the meeting starts. Besides that, this section also says that the notice of the meeting should be sent to each of the creditor, comprising a statement of list of the names of each and every creditors and the amount of their claims. Moving on to the fourth step, which is from Section 449 subsection 4. In this section, it is stated that the meeting held should apprise extensively in all local newspapers with the national language, which is English. The last step is from Section 449 subsection 5. In this section, the directors should ensure that the full statement of company's affairs is present so that it will enable the dissolution of the company to take place. Not only that, the directors should also appoint one of the director to attend the meeting which will be held for the dissolution of the company. And that's all the steps for dissolving the company. That's all for our presentation today. Thank you very much for being such a wonderful audience.